Michael Popok, Legal AF. It is time for Jack Smith to start cutting Donald Trump off at the pass, get ready for the March 2024 trial, and preclude his ability, Donald Trump's ability, to introduce irrelevant evidence to try to obtain what's called a jury nullification, which is that the jury completely ignores the actual facts that are developed and introduced into evidence in the courtroom and the judge's instructions about the law and just sides with Donald Trump because he's introduced irrelevant, prejudicial, highly explosive theories that have no basis in fact or connection to the indictment or the charges that have been brought against him. So Jack Smith has filed today, as if he's going to trial in March, a motion in limine, which is a motion to preclude certain types of evidence from being introduced into the jury and to pollute the jury's mind in any way, shape, or form. Motions in limine are filed in almost every case. I'm a trial lawyer. I will tell you that whether it's a civil case or a criminal case, there's always a fight over the motions in limine. Defense lawyers primarily want to introduce lots of evidence that they believe is explosive, but whose probative value, the value of proving or disproving a fact in a case, is of low quality, or where the prejudicial impact on the jury, perhaps even leading to that jury nullification I just talked about, where a jury rejects the law and the facts in the courtroom and just rules emotionally. That could happen if that prejudicial impact overwhelms whatever limited, probative, or relevant value of that piece of evidence, then it gets precluded as well. This is under the federal rules of evidence. This isn't special rules designed for Donald Trump. These are the federal rules of evidence 401 and 403, and the balancing test that the judge has to make when these issues are brought before her. So Judge Chutkan, ultimately, whenever this case and the pin that's in this case, whenever the case is moves forward after the D.C. Court of Appeals rules in early January, and maybe the U.S. Supreme Court rules about whether Donald Trump has immunity from prosecution, in the meantime, the prosecutors are moving this case forward as they should and letting the world know that they've had it with Donald Trump and his attempts outside the courtroom. I don't think it's any surprise that the more Donald Trump acts out and tries to attack the prosecutor, including trying to send him to hell and rot in hell, as he just did over Christmas weekend or Christmas week, that has strengthened the hand of the prosecutor to bring a motion like this. I think the timing of filing this motion right after the Christmas meltdown of Donald Trump, where he tries to send the prosecutor to rot in hell, only inures to the benefit of the prosecutor and strengthens his arguments on this motion in limine. I'm going to read from the actual motion in limine, the motion to limit evidence, for you so you know exactly what we're talking about. This is the government's motion in limine. It was just filed, and on page 1, first paragraph, it frames the issues. Quoting from the motion, through public statements, filings, and arguments in hearings before the court, the defense has attempted to inject into this case partisan political attacks and irrelevant and prejudicial issues that have no place in a jury trial. The court should not permit the defendant to turn the courtroom into a forum in which he propagates irrelevant disinformation and should reject his attempts to inject politics into this proceeding to ensure that the jury remains focused on its fact-finding duty and applies the law as instructed by the court. That's the jury nullification issue I talked about. The defendant's improper evidence and argument should be excluded. What is he talking about? He's talking about all of the arguments Donald Trump makes that the Biden administration, working in conjunction with the special counsel's office, is going after his political enemy, Donald Trump. All of that, which has no basis in fact, it is all untrue, needs to be not introduced into evidence or argument, oral statement, closing argument, Donald Trump taking the stand in front of this jury. That's the first argument, because it has no connection, has no relevance to the facts that underline any of the claims or any of the defenses, any of the charges or any of the defenses in this case, plain and simple. So it really, this motion in limine falls into two buckets. It's going after Donald Trump where Donald Trump lives, in the dirty mire of social media, making baseless attacks where that works in that world, but doesn't work in an evidence-based world of a courtroom. And then that's the political attacks. And then the second is all of the BS theories, which have no basis in law or fact, that Donald Trump likes to spout at rallies on social media, in interviews and the like, about foreign influence in the election, that the Russians are controlling the election and the election outcome. He won't be able to do that, that there's fraud in the last election and there's fraud potentially in this election and the like. And so those are the two different categories. I'll go through each of them using the motion as my guide, and we'll put up on the screen the various issues that are relevant. On the political side, on page 3 of the brief, Jack Smith's team says, significantly here, where the defendant, Trump, repeatedly has levied baseless political claims, evidence or argument that serves only to support a jury nullification argument has no relevance to guilt or innocence, and it must be excluded. So anything, just as a first cut, that doesn't bear on the defendant's guilt or innocence, they want the court to exclude. And they don't, for instance, this vindictive prosecution or selective prosecution argument has no facts, has no relevance, and a selective prosecution claim is not a defense to a criminal charge at all. Some people think, well, they've gone after him. It's the Biden indictment or it's the Injustice Department and they're selectively prosecuting. That is not a defense to a federal crime as under the case law. So it has no place in any of this. Of course, they're quoting to Donald Trump's social media. And any other of his baseless attempts, Donald Trump, to impeach the investigation, no pun intended, and to say there's been some sort of investigative misconduct when there has not been, needs to be barred from the courtroom. Now, look, that's not to say if there were real prosecutorial misconduct that Donald Trump would not be able to raise that issue on a due process violation claim to have the indictment or the prosecution dismissed. But he has not filed that motion. That motion doesn't exist because Donald Trump doesn't have the basis to file it. So if he can't file a motion for prosecutorial misconduct to seek the dismissal of the indictment, and Lord knows Donald Trump and his lawyers have thrown everything at the wall related to the indictment to see if it would stick. Every ground they can think of to get the indictment dismissed, including immunity. But not one time did they allege prosecutorial misconduct. So they shouldn't be able to try to backdoor that issue into the courtroom and in front of the jury. That is Jack Smith's argument here on his motion. Jack Smith also doesn't want any legal issues related to any issues that the judge, as the giver of the law, the lawgiver. There are issues that are reserved for the court to instruct the jury properly on the law. And they don't want Donald Trump coming in there and giving his version of what he thinks the First Amendment is. The First Amendment is or is not a defense to this case. And the judge, in wearing a black robe, not Donald Trump wearing a red tie, is the right person is the only person to instruct that jury. And so any of Donald Trump's legal arguments that fly in the face of the law, they don't want to see inside of the courtroom. The consequences of Trump's criminal case is also something that they don't want Trump to be able to tell the jury because it has no place under the law. As they say on page 8 of their brief, as in any other case, the consequences that the defendant may face as a result of the criminal case against him or a conviction are irrelevant to guilt or innocence and may not be considered by the jury. So he can't get up there and say, Joe Biden's trying to take the election away from me. If you convict me, I will lose the election. Or I'll go to prison for a long, long time. You can't make those arguments to a jury. It's actually would lead to a mistrial within the jury. So Jack Smith wants to make sure those arguments aren't raised. January 6th and the aftermath of it is a subject of the motion to exclude irrelevant and prejudicial evidence. And what they're focused on here is that they don't want Donald Trump to introduce disinformation about Jan 6th into the courtroom. Talk about the Jan 6th defendants as heroes, as political prisoners, that he's sung songs with them and the like. They don't want Donald Trump improperly commenting about Jan 6th in front of this jury. And that's a balancing test that the judge has to make because of the very weak connection to the central issues in the case. And so that needs to be excluded. This BS argument that there were undercover officers or government officials at the Capitol on Jan 6th, of which there is no proof. They don't want that introduced to the jury. Because that'll just, first of all, it's untrue. Second of all, it'll just blow the mind of the jury and distract them from the matters at hand, which is the facts and law being introduced in the courtroom about the indictment. So that doesn't go to any element. It doesn't go to his mental state. It doesn't go to any elements of the crime. And therefore, they shouldn't be able to introduce evidence to try to confuse the jury about what the true issues are. On page, I find this interesting, on page 13, they go over and they want the court to exclude any evidence of alleged foreign influence. That's an interesting choice of words. They're not saying that there wasn't foreign influence. They're just saying that there should be evidence that is excluded related to it. In the first paragraph on page 13, they say the defendant has indicated that he intends to introduce evidence of foreign influence in the 2020 presidential election and the like. And so they don't want that introduced at all into the jury's minds. For instance, the defendant, this is the top of page 13, the defendant has indicated that he intends to introduce evidence of foreign influence in the 2020 presidential election to show that he was personally tricked by foreign disinformation and or the January 6th riot resulted from efforts by foreign actors to influence public opinion. Such evidence should be excluded as an irrelevant and confusing sideshow. As to any claim that the defendant was fooled by foreign influence, absent a concrete showing that the defendant relied in good faith on specific foreign disinformation when making a particular false claim, such evidence will be irrelevant to his mens rea, Trump's criminal mind, and will only distract the jury from the issues properly before it. So they want to cut the legs out from Donald Trump to be able to argue anything related to foreign influence, since there's no chance he in good faith relied on it. And then finally, the other issue that I find interesting is that in general, they don't want Donald Trump from introducing or attempting to introduce evidence of after the crime changes to the election law. There have been changes to the election law about the vice president's ministerial role in the congressional certification, for instance. The Electoral Count Act was amended. But that doesn't mean that at the time that Donald Trump put a pressure campaign on Mike Pence, that it wasn't still part of the criminal conspiracy. And so they want to make sure the jury is clear on that. Now, what happens next with this filing and this attempt to keep out this evidence in this motion that's been filed? Now, Donald Trump has taken the position, and the judge has taken the position for now, that the case is stayed, meaning a pin is put in it. It's been put on ice until the ultimate resolution of the immunity issue is completed through the D.C. Court of Appeals and then the Supreme Court, U.S. Supreme Court, which had happened sometime in January. But this motion will be on the docket, waiting for Donald Trump. I don't think he has to respond to it right now, because all of the proceedings are stayed. They're all on ice for right now. But as soon as the stay of the case is lifted by Judge Chutkan through the appellate process in January, then the time for Donald Trump to oppose this motion, file his brief, Jack Smith to file his second brief, because the movement gets two briefs and the opposing side gets one, and then the judge will rule on it. I think this gets ruled on in January, maybe early February, well in advance of the trial in March. Motions in limine sometimes get decided during trial. I've had motions in limine decided for or against me, on the first day of trial, 3-4 days into trial, as the evidence is being introduced. Now, generally, it's done before the opening statements so that everybody knows the rules of the road on both sides of the case about what they can and can't introduce into evidence. You want to know that before you start addressing the jury. So I expect that as long as it's done before March 4th and maybe a week or two before, so there's plenty of time. But this is a signal. This is Jack Smith also trying to control the narrative and the media messaging by filing these motions and saying we're not sitting by. We're going to docket these items. The clerk has not closed the docketing of filings in the case, meaning how they end up on the electronic list of papers that have been filed in the case. That's still open for business. The judge hasn't ordered the clerk to refuse to accept any filings in the case while the case is stayed. It just means she's not going to progress the case, and the timelines and the deadlines established by the federal rules are not being applied right now. The clock isn't ticking on responding to these things. But if Jack Smith wants to file a dozen or more motions to have them ready to go and sitting in the docket, waiting for Donald Trump to have to respond to them, and Donald Trump doesn't want to move on them, which is fine because the case has stayed, then he'll have a lot of work to do and a lot of homework to do once class is back in session and the case is restarted. That's all Jack Smith is doing. Stacking up, cutting and stacking up his wood, right? Waiting for that moment, because otherwise he'll run out of time. If he wants to keep the March trial date, Jack Smith and his team have to continue to progress the case the best way they can, which is to file all the motions they can that need to be addressed by the court in advance of the trial, rather than lose an entire month or two and then have to start from scratch. There's no rule that says that. I know Donald Trump is going to jump up and down, probably maybe before my hot take gets up. It's, the case is stayed and Jack Smith's being a bad boy. He should rot in hell, or whatever he's going to say. But the reality is that the docket is open. The clerk's office is open for business electronically, and they can file whatever they want. They want to file every one of their papers that they need to take the case to trial in March. They can. It's just for right now, Donald Trump doesn't have to respond to them, which puts Jack Smith in a great position because he gets a one-sided conversation with America. Here's all my papers. Here's everything that we're going to argue. Here's all the bad and ridiculous things that Donald Trump has on his side of the case from my perspective. And yeah, we'll get around to hearing from Donald Trump maybe a month or two from now. I think it's genius. It keeps the case on track. He has to do this. It's from a strategy standpoint. If he has any hope of keeping the March trial, he needs to signal to the world that he's ready for trial, and he's doing everything to get ready for trial. And he also gets the added advantage of being able to tell his story, the Jack Smith story against Donald Trump, without Donald Trump responding except in social media, which only helps these motions. So it's genius. It's another trap by Jack Smith that we know that Donald Trump will fall into. We'll continue to follow all the filings in the D.C. election interference case, the appeal on immunity at the D.C. Court of Appeals level, and ultimately the U.S. Supreme Court as this case motors towards March and a trial date. Only one place, the MeidasTouch Network on Legal AF, Wednesdays and Saturdays at 8 p.m. Eastern Time. Join us on YouTube, and then on audio podcast platforms wherever you get your audio podcast from. Give me a thumbs up for this hot take, helps with the ratings. And until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.